Okay, hey gun people, finishing this will be, I don't know what part, I'll name them later, on the exigency, understanding exigency, how government is circumventing the Constitution, and how the courts see this. So if you're watching this series, you've probably already watched one or two, and there'll be a couple more. Here we go. So this is U.S. versus Andy. I'll just say Andy for short. Could DEA agents lawfully enter a house if, although they had consent from an incarcerated resident, they were refused entry by a resident present? That's a pretty good question. So, could DEA enter the house if they are refused entry by a resident who is present versus we have a consent from a person we arrested? Interesting question. Who knows the answer? Who thinks they know the answer? Well, you're probably wrong. All right. Apart from consent, did an exigent circumstance justify the warrantless entry? Again, we've talked about warrantless entry. Only two ways to get into a house or residence: warrant or consent. If you don't have those, then you need exigency. If so, did the exigent circumstance allow them to enter the kitchen and the second floor? This is interesting because if you enter on exigency, I think you have the whole house. When I talk about having the whole house, it means I control it, I seized it. If I make an entry into a house for whatever reason, if I force entry because of a warrant, even if a consent, I kind of have control of that house. Now, the consent can be withdrawn at any time. So even if you give consent, you can pull consent. If you give consent, you can restrict consent. I'll give you consent to search my living room only. I'll give you consent to search my couch only. I'll give you consent to search my kitchen only. You can give consent that is limited. The problem with that is once I get limited consent, if I find a crime, now I get to seize the whole house. So anyway, the only time I would give limited consent is if the cops showed up and said, hey, we heard you have a bomb in the back of your truck bed, and we would like to take a look in your trunk bed. I'd be like, I'll give you consent to look in my trunk bed because it's empty. Let's go. That's it. Nothing more. So that is what's called limited consent. Now, if they get to the truck and they go, do you mind if I look inside the car? Yes, I do mind. And you don't have a warrant, and I'm not giving you consent. I consented to the trunk bed. You looked. Now you need to leave and go get a warrant. So you have to make sure you understand exactly what your rights are, and you have to make sure you articulate those rights to government, who is the police, when they're there. All right, facts. Here we go, some facts on the case here. In the course of a DEA, man, those guys are good, investigation, agents in Buffalo, New York, arrested Anderson, who later gave written consent to search his home. Anderson is a freaking idiot. He's in custody, and he gives the cops to go search his house, and he knows there's drugs there. I mean, you got to be some kind of special idiot to give the cops have arrested you and you're in jail. There is no reason to cooperate with them, and you give not verbal consent, written consent to go search your home, knowing that your wife is there or girlfriend and they're going to be arrested. Okay, so I'm pretty sure Anderson is an idiot, but that's just my opinion. Rick, he's trying to cooperate with law enforcement, and that's what we need more of to help police. Well, that's because you're an idiot too. All right, so Montez, who is Anderson, or Montanez, whatever, Monty, I'll call him. Monty informed the agents that he shared a house with his girlfriend, who he just pretty much sold down the freaking river and got her ass arrested. And that he had hidden a couple of ounces of cocaine in a book bag. I'm not sure what a book bag is. Oh, a book bag, like the bag you carry on your back for books for school. Okay. In a book bag. And that Yvette, his girlfriend, could show them where it was located. So he gives consent. And then when his girlfriend shows him where it's at, guess what happens to girlfriend? She gets arrested for possession. Anyway, I digress. He's an idiot. DEA agents arrived and Buffalo police officers arrived at the house at 11 p.m. and surrounded it. Now, this is 11 a.m. at night. After 10 p.m. in most places, that's considered night service. And if you get a warrant, you can't serve a warrant after 11 p.m. unless you justify to the courts why there's a need to serve it and why you need to do it so late, because at 11 p.m. at night, people can think people are breaking in. There's more likelihood that a shooting occurs. Okay, so 11 p.m., they surround the house. When agents walk to the front door, they discover there was an outer and inner door. After they knocked on the outer door, female opened the inner door, and the agent identified himself and informed her that Monty, who was in jail, had consented to a search of the premises for his cocaine. Now, let me tell you pesky citizens something. If the cops ever show up and say, someone else who lives in a house gave me permission to come in and find drugs, and you say anything other than, show me the warrant, I don't consent, and I shut the door, then you're an idiot. Okay? Because I can walk up to you and say, your mom told me that she had prescription drugs she wasn't supposed to in her house and she gave me consent to go search it. Please let me in. And if your dumb ass lets me in, then anything I find will be used against you and grandma because you're an idiot. Rick, you can't call people idiots because, shut up, you freaking crybabies. All right. So after they told her this premises, the woman asked to see a copy of the consent form. Good for her. But when she saw it, which means they showed it to her, she slammed the door shut and ran into the kitchen. We talked about this furtive movement. Your actions send messages. Your actions can give exigency if you react like you're a criminal and consciousness of guilt. So she slams the door and runs into the kitchen after she sees consent. The agents then heard the sounds of running water. Ooh, the old running water exception. And opening and closing of kitchen drawers. Now, look, if somebody runs and a guy already told you there's drugs in a house and the woman slams the door and runs and now you hear kitchen cabinets, it's reasonable to believe, most reasonable people, I know there'll be people here that'll be arguing with me, it's not reasonable. Most reasonable people believe she knows the drugs are in a house, the gig's up, and now she's about to flush them or wash them down the drain. To me, that's reasonable. Since she was obviously flushing the cocaine, agents forcibly entered and arrested her. I'm okay with that. I think they're good to go there because of her actions. Had she just said, I don't believe he gave consent, I live here, and I'm not giving consent, therefore you can't come in and go get a warrant, and shut the door, then if they kicked the door, she would have a better stance. But I still think the cops would win. Because if you shut the door on me when I know there's drugs or I have reason to believe there's drugs, and the reason I have reason to believe there are drugs is because a person who I arrested gave me consent to go look for the drugs and told me they were his drugs and they were in the house. And when people give statements against their penal interest, that's the term that's used in court, when you make stupid statements that pretty much implicate you in a crime. When somebody makes statements against their penal interest, cops and government has a right to believe those statements. So this guy gave statements against his penal interest. I think there's drugs in here. I have a right to believe there's drugs in there. And someone else, after I tell him that, slams the door and starts flushing, I'm going in. Rick, you're a big bootleg jackhammer. Well, sorry. The agents then heard, was obviously flushing cocaine. They entered and arrested her in the living room. They arrested her as she entered the living room from the kitchen. Now, to me, that doesn't matter. Once I'm in a house, again, the house is mine. I control it. I can do a protective sweep. The house is mine. As long as I got in there under reasonable circumstances, it belongs to me now. And it belongs to me in the concept that I can secure it. I can do a protective sweep to make sure nobody's going to come out and shoot me or hurt me or destroy evidence. And then once I do that protective sweep and I make the house safe, now I lock it down and I go get a warrant. And I'm locking it down to prevent destruction of evidence. So that's all legal. I got no problem with that. Okay, agents then went into the kitchen. I'm okay with that. Turned the faucet off. I'm okay with that. Seized a baggie of cocaine. I'm okay with that. When officers are where they're allowed to be, they're allowed to seize evidence they see in plain sight. If the water was running, they turn the faucet off. There's a bag of cocaine in the sink. They see it. They can seize it. And they can use that to go get a warrant. Then, while conducting a protective sweep, we talked about that, of the second floor to make sure nobody's going to come out and ambush them, they saw a book bag and seized it. I don't know about this one. Now, because they were given written consent and they were looking for the book bag, because they didn't see drugs, did they seize it under the plain sight doctrine? It's in plain view. Or did they seize it because of what the guy told them and they thought it contained it? I don't know if either one is wrong. I probably would have just pointed out the book bag. That would have gave me corroborating evidence that I saw while I was doing a protective sweep, and I would have put that in a warrant to go back and seize it through the warrant. To me, that makes it cleaner, and there's less way that the defense can come back and try to suppress it through bullshit. That's the way I would have done it. I think that would have been a better way, but the DEA, those guys are good. They decided to seize it. Okay. Both the idiots were charged with, among other things, conspiracy to distribute cocaine. Before the trial, they filed a motion to suppress. Shocking. Wow, that's never happened. In the sink on the grounds that the agent's warrantless entry into the house, it may have been warrantless, but I think it was justified through exigency, that the warrantless entry into the house was not justified by exigence or consent. I think they had written consent and they had exigency, but we'll see. Even if there were exigence, the exigency ended when the agents arrested her in the living room. I don't believe that, but anyway, that's what the motion said. The defense court, or the district court, summarily denied Montana's motion because he consented to the search. So Montana, meaning Montana's lawyers, tried to get it suppressed, and the court went, "You're freaking crazy." He gave him written consent when he was in custody. As long as they didn't coerce him, they had consent. We're not suppressing his motion. He told them to go get it. Okay, Montez did not appeal this ruling. That makes the case even stronger, because he had the standing for getting them in there with consent. But the district court granted the female's motion as follows. It ruled that the agent's entry into the house was lawful because they reasonably believed that Antonio was in the process of destroying evidence, which falls under the exigency circumstance. But it also ruled that the agent's entry into the kitchen and the second floor was unlawful because she had already been arrested. I think the court's on freaking crack. They're freaking crazy. They didn't enter the upstairs and the kitchen for any reason other than to do a protective sweep. Now, you could argue maybe they didn't enter the kitchen to do a protective sweep. They used it to turn off the water and to prevent destruction of evidence, which also falls under exigency. So I think they're okay. I don't know how this turns out. I can't remember. I glanced through it. Let's see. The second floor was unlawful because she had been arrested in the kitchen. That's bullshit. And was therefore unable to destroy anything. That's true. She couldn't destroy anything, but the cops didn't know whether anyone else was in the house. And even if she said no one else is in the house, I don't believe criminals. I would have searched. I would have done a protective sweep for officer safety so we don't get ambushed. So I think the cops are golden here. The government appealed to the Second Circuit. Discussion. On the onset, it should be noted that the government did not challenge the district court's ruling that the agents did not have sufficient grounds to conduct a protective sweep of the second floor. This was probably because they had no reason to believe that anyone but the female was on the prison. That's not true. Why would they have any reason to believe that? Because the guy in jail told them? Because the guy in jail that said he had cocaine in the house told them, so he should believe him? Because the girl tried to slam the door and tried to destroy, they should believe her? That's freaking crazy. Consequently, the only issue on appeal were the legality of the warrantless entry into the house and into the kitchen. If you get the house, I get the kitchen. I don't know what the hell they're arguing about. I think they're crazy. Okay. Entry into a home, consent. Although Monty consented to the search, Andrea, whatever, did not. And although the officers are not required to seek consent from all residents before entering, and this is what I was kind of talking about on the Tim Pohl entry. The guy at the door may have, and I'm not saying he did, I'm not trying to get anybody in trouble or anything, I'm just saying legally wise, they're going to be able to argue he was a resident, he answered the door, he even asked if we had a warrant, And then he opened the door and escorted us around the premises, which is quasi-consent because he didn't continuously object, or he didn't object clearly, saying, look, if you enter this house, it's against my will. I'm in control of the property. I can bring the property owner down. He will also say you do not have permission. And now it's absolutely clear in every court and in every jury's mind that there was no way the officers could have possibly misinterpreted a possible halfway consent to search for injured parties. That's why I've got a problem with the officer's entry, but I don't know how it's going to play out in court because I don't know all the facts. I mean, I would, like I said, I would go on pools and discuss it and have them question me, and I would give my opinion, but whatever. Okay, the Supreme Court, Georgia Rudolph, ruled that if one resident in the house consents to entry or search, the consent is invalid if the non-consenting resident affirmatively informed officers that he objected to the search. 2, this objection was voiced in the officer's presence when they sought to enter. So, according to Georgia versus Randolph, if me and my wife were at the front door and I say, you can search the house, and my wife goes, not no, but hell no, get the hell out, you can't search the house, I've got control of it, he's got control of it, you can't come in. Now, I thought when I was working that as long as we got consent from one party, we were good. I don't know what the date is of this ruling. It may be after my time. But it sounds like now one party can object and the other one can consent, and the objection overrides the consent. That's what I'm reading from this little statement here. I haven't researched it. The objection was voiced in the officer's presence and sought to enter. Okay. Based on the female's express refusal to consent, which she did, she slammed the door. Slamming the door is a quasi no. I know some cops will be like, well, I didn't know she meant no. I thought she was slamming it because she was scared of a spider and she was trying to kill it. And that's why I went ahead and entered, because I didn't hear her say no. That's why you want to always give good affirmative denials. You do not have consent. I do not consent. Go away, come back with a warrant. I'm shutting the door. Make them forcibly stick their foot in the door. Make them forcibly stop you from closing the door. Make them say, I don't care that you don't want us coming in. We're coming in anyway. Now you're covered legally. And that's what I'm not sure happened at Tim Pool's entry. Let's see. By slamming the door, because she did so when the agents announced their purpose, the court ruled that as to her, the agent's entry into the house could not be based on his consent. So they got a win there by her slamming the door. Even though he consented, the court said, hey, her slamming the door and saying no negated the consent. Okay, I'm okay with that. Entry into the home on exigency. All right, here we go. The question then was whether the agent's warrantless entry into the house was justified through exigent circumstances. Officers may, of course, enter a home without a warrant if they reasonably believe there was destructible evidence on the premise that would be destroyed if they waited for a warrant. That's true. I'm not sure how they worded that. Basically, if you think that something of evidence could be destroyed, tampered, or manipulated, you have a right to seize that or seize the house to prevent that destruction, only to give you time to go get a warrant. As the Supreme Court explained, to prevent the imminent destruction of evidence has long been recognized as sufficient justification for a warrantless entry. In light of this rule, the Second Circuit reversed the trial court and ruled the agent's entry into the home was in fact justified by the exigency circumstance. I agree. Specifically, the court ruled that the combination of the following circumstances demonstrated that a sufficient threat to the evidence has to justify warrantless entry. Let's see what they said. 1, based on the information Montana, the agents reasonably believed there was cocaine on the premises. I agree. 2, after the agents identified themselves and told her that Montez had consented to search the premises, she slammed the door shut, ran from the door, turned on a faucet, started opening, closing closet doors, said the court. These are classic sounds indicating destruction evidence. I agree again. Entry into the kitchen. Was that exigent circumstances? I think entry into the kitchen was exigency, because even though she wasn't there, as she dumped cocaine in the sink, the faucet could be destroying evidence. So I could go over there to prevent the destruction and turn off the faucet. When I turned off the faucet, I saw cocaine. I think they're still legit, but let's see what the court said. So the female attorney argued that even if the agent's entry into the house was lawful, there could not enter the kitchen because she had already been arrested in the living room. Therefore, she had no ability to destroy anything in the kitchen. Yes and no. Because the faucet was still I would argue because the faucet was still running, I was still concerned that there was evidence being destroyed on her actions before we got in there. Therefore, I can stop that destruction by turning off the water. So therefore, I was authorized to go in the kitchen. That would be my argument if I was on a stand or somebody was trying to question me. Although the district court brought this argument, the Second Circuit rejected it, mainly because they could hear the faucet running. This indicated that some evidence was still being flushed. Therefore, said the court, the officer's entry into the kitchen after physically securing her was justified by a continuing exigent circumstances. I agree. And because the cocaine was in plain view when the faucet was closed, I agree. The court ruled the district court erred by suppressing that evidence. I agree. So in this case, I think they were okay. Some people may. Again, you have to... It's one thing for idiots like Asp to get on the air and repeat what cops say. Cops say there was exigency, therefore exigency. But to understand how and why the court ruled this, to actually have experience going in a house and dealing with these issues on the fly and making these immediate decisions in the crazy situation that now you have to justify later what was in your mind when you acted and was it reasonable. So again, that's why I have a problem with people like Ass teaching and evaluating cops' actions when he doesn't have the first damn clue because he's never carried a gun or anything. And people come here and tell me, dude, if you want to know what you're talking about, you need to go watch Ass. I'm like, you guys are freaking idiots. But anyway, I digress. Look, exigency is a simple thing for me because I've dealt with it on the fly and in court hundreds of times, and it's not a big deal for me. But as you can tell, if you just watch my videos, I think I've done 2 now. If you watch these 2, each case has particulars that you need to understand the law and how the court's going to view it. And even if you do the right thing, the court may override you. And then another court may say you were right. And then another court may say you were wrong. So I don't really care what the courts say. I care that I understand the law, and when I'm applying the law, I'm doing it with the spirit and intent of the law, and I'm doing the right thing, because that's what cops are supposed to do. We're supposed to abide by the law and do the right thing. We're not supposed to try and circumvent the Constitution just to stomp on the pesky citizens' rights to privacy. All right? So I'll make another one. I think it'll be part 3. I think this is part 2. And we'll end that there.